Assalamualaikum and hi, my name is Farhah Najiha Muhammad Fairuz, matric number 054997. Today, I would like to present the assignment for the subject of jurisprudence, which was to draft an Act of Parliament. Firstly, my group and I had drafted an Act of Parliament, which is the Family, Marriage, Divorce and Custody Act 2022. The Act is divided into 5 parts, which are Part 1 is the preliminary, Part 2 covers on marriage, Part 3 covers on dissolution of marriage, Part 4 on custody and care of a child, and Part 5 on marital violence. For Part 1, which is the preliminary, Section 1 stated that this Act may be cited as the Family, Marriage, Divorce and Custody Act 2022. It shall come into force on such date as the Yang di-Pertuan Agong may, by notification in the Gazette, appoint, and different dates may be appointed for Peninsular Malaysia, Sabah and Sarawak. In regard to my part, which is on the custody and care of a child, the interpretations of the words Baligh means the age of puberty in accordance with Hukum Syara, and child means any children who had not attained the age of 18 years old, stated in Section 2 of the Act. Section 3 of the Act provides that this Act shall apply to citizens and those who domicile in Malaysia. Part 4 of the Act is regarding the custody and care of a child. It consisted of 3 provisions, which are the order for custody, custody according to the legitimacy of the child, and order for maintenance of children. Firstly, Section 10, subsection 1 provides that the court may at any time order a child to be placed in the custody of his or her mother or his or her father, which the court deemed had acted in good faith over the course of the father's or the mother's life. Subsection 2 of the same section mentions that with the welfare of the child as the utmost consideration in mind, the court shall consider the matters stated in para A, B and C in determining whose custody a child should be placed. The matters to be considered are the wish of a non-Muslim child which had reached puberty and able to express their opinion independently, and the wish of a Muslim child which had attained the age of Baligh and able to express their opinion independently, and the parent who is claiming for custody must be able to prove that he or she had acted in good faith over the course of his or her life. So for drafting Section 10, I relate this provision to natural law and morality. One of the scholars of the naturalist school, which is Thomas Aquinas, had divided law into 4 categories in accordance with the concept of natural law. I relied on lex humana, which is humanly posited law, to draft this provision. So Aquinas had categorized the law as lex humana, whereby the law is created for the common good and supported with reason. So in applying to this provision, I highlighted the act of good faith in determining who should get the custody to show that law and morality relates with each other. Therefore, with this provision, the concept of lex humana is applicable as it is compulsory for a person to always act in good faith and not be selfish in their life. The section is created for the common good of every person as the future of the custody depended on the quality of their life. Thus, this section is drafted with the hope that every person will be a better human being. Meanwhile, Section 11 provides that, subjected to Section 10, if there is no order from the court, the mother shall be entitled to the custody of a legitimate or an illegitimate child. In this provision, I relate it to cultural feminism. The feminists had argued as the women get pregnant, equality should be accounted for. They stated that the experience of motherhood causes social and psychological disparities between men and women. Therefore, this section gives the entitlement for the custody of the child either legitimate or illegitimate to the woman, as according to cultural feminism, women are more attached and loving than men since they give birth and nurture the child. Lastly, Section 12, subsection 1 of the Act stated that regardless of whether the father is capable or not to the maintenance of his children, the court shall order the father to provide maintenance of his children, whether or not they are in his custody, by providing them with basic necessities such as shelter, clothing, food, and education as may be adequate for the children. Meanwhile, subsection 2 of the same section provides the punishment which is subject to subsection 1. Failure to provide maintenance for the children, the court shall punish with imprisonment for a term not more than 6 months, or a fine not more than double the amount of maintenance for the first offence, and for a second or a subsequent offence he shall be punished with imprisonment not more than 1 year and whipping not more than 5. So therefore, I relied on Islamic jurisprudence and legal positivism when drafting this provision. In Islamic jurisprudence, regardless of their gender, a father is obligated to provide maintenance to his children. If their father passes away, the grandfather should assume responsibility for them. It is based on Allah's word in Surah Al-Talaq, verse 6, where it talks about the need to provide support to the wife since they breastfeed the children, and it is preferable to supply the maintenance directly. Furthermore, according to Surah Al-Baqarah, verse 233, a child's family lineage is to the father, implying that the father is accountable for the child's upkeep. Following that sentence is a sentence emphasizing a father's commitment to care for the child's mother's maintenance while she breastfeeds the infant. So as a result, it can be seen that providing the children maintenance should be prioritized by the father more than anything. So next, I also relied on legal positivism to draw the punishment of these provisions. I drafted section 12 of the Act by relying on Bentham's theory of law, which is the doctrine of utilitarianism. The punishment for the father who failed to provide maintenance for his children is to increase the society total happiness and help to prevent a greater general pain. So the creation of this section is to prevent any father from avoiding to provide the maintenance of his own children, and the punishment serve as a reminder for every father to fulfill their responsibility towards their children. With this, the provision will increase the society total happiness, which in this case the children, and prevent the mother or the children from having a greater pain of not receiving maintenance from the father when they are in need of it. That is all for my presentation. Thank you.